Hey, Mandy here, CEO of Thrive Inside Nonprofit. And I created this video so I can teach you and your loved ones their constitutional rights when it comes to solitary confinement. So let's get into it. Historically, until the mid 1960s, keeping prisons orderly has always been a challenge for administrators, as they must pursue some means of dealing with our incarcerated individuals who violate rules and regulations. One such technique is punitive isolation, which isolates the offender from the rest of the prison population as a punishment for violating institutional rules. Prior to the mid 1960s, state detainees who were objected to solitary confinement or the conditions of such imprisonment were denied remedy under the following hands off doctrine. Almost every correctional facility has a special confinement unit for those who have committed major misbehavior while detained. This prison within a prison is usually a location of solitary confinement with restricted food, limited access to reading materials and other distractions, and, on occasion, no light. Another means is administrative isolation, which is isolation from the general population for any reason other than punishment, such as protective isolation or isolation during the investigation of an alleged institutional rule violation or a felony. Our federal courts utilize this doctrine, refusing to grant relief to caged individuals who challenge the use and or conditions of isolation. The federal courts ruled it as an internal prison concern and beyond the powers of the courts to supervise. As far as state prisons, federal courts maintained the administration of prisons lies within the powers reserved to states under the 10th Amendment. A federal judicial review would interfere with the administration of prisons, the court claimed. According to the court, they have limited authority to monitor prison rules and regulations. Thank goodness this no longer happens. Ready for an extra bonus? Did you know laws are vague, unclear, and undefined because legislators are not always diligent in narrowing down the language to a clear definition? It takes a lot of work, and some find it easier to leave it vague. This results in confusion, unnecessary lawsuits, and punishments. I don't know about you guys, but history was quite some time ago for me. So I'm going to go ahead and give us a crash course and remind us of what the Eighth Amendment actually is. So, the Eighth Amendment to the United States Constitution prohibits the federal government from imposing excessive bail, excessive fines, or cruel and unusual punishments. Now, my loved one's bail is $2 million, and that seems quite excessive to me. So, what can we do? Well, it starts with legislation. It starts with really making sure that who we are electing is all about prison reform. That is step one. What other steps do you think we can take? Getting back to solitary confinement, in order for a federal court to review an incarcerated human's isolation complaint, there must be a cruel and unusual punishment violation. Now, the Supreme Court established this clause prohibits three things. Number one, torturous punishments. Number two, unnecessary cruelty, inhumanity, and barbarism. Number three, an unnecessary punishment considering its intended purpose. Punishment must be involved to apply prohibition. According to criminal law, punishment is defined as any fine, penalty, or confinement inflicted upon a person by the authority of the law and the judgment sentence of a court for some crime or for his omission of a duty enjoined by law. Correctional law defines punishment as having four elements. 1, action by an administrative body. 2, which constitutes the imposition of a sanction. 3, for the purpose of penalizing the affected person. and 4, as the result of the commission of an offense. A court examines both the duration of the confinement as well as the conditions the caged human was subjected to when making its determination. Solitary confinement and constitutionality. Many incarcerated people have questioned the validity of solitary confinement, both state and federally, alleging that being confined alone in a cell is unconstitutional and that no proof is required. Rejected. The federal courts consider it a valid means of protecting the general prison population from disobedience, disorder, or escape. Accepted. They do accept, however, that isolated confinement can be excessive or utilized incorrectly, thereby violating the Eighth Amendment. Unfair method. Furthermore, the method by which isolation is imposed may be inherently unjust, constituting a violation of due process. Our Seventh Circuit claims isolation alone is not a constitutional issue. Because they have no property or liberty interest in remaining in the general population, the Civil Rights Act cannot be utilized to challenge their segregation. Constitutionality, confinement, conditions. Those who are held in solitary confinement in violation of the Eighth Amendment's prohibition on cruel and unusual punishment have the right to seek remedy from the federal government. When this happens, what is there to do? Well, the burden is on our incarcerated. The unconstitutional conditions must be proven. If the alleged conditions is not sufficiently proved, the complaint will be denied. It becomes a legal issue when a violation of the prohibition against cruel and unusual punishment is proven, rather than a factual issue. The court, not a jury, will then determine whether the Eighth Amendment has been violated. Each court looks at the personal hygienic conditions of the incarcerated human, the physical state of the cell, allowance of exercise, diet or lack thereof, duration of the solitary confinement. If you do decide to take action, here are some cases for you to study and draw from. The courts view the proper purpose of solitary to be the maintenance of order within the institution. It is a violation of the Eighth Amendment to be punished for an improper purpose. Therefore, any punishment that is not necessary to maintain order is cruel and unusual and prohibited by the Eighth Amendment. The following are examples of disproportionate punishments. Let's take unsanitary conditions. Lacking toilets, running water, facilities ridden with vermin and fire hazards, things of that nature. Then we'll head on over to the showers. Showers only producing scalding hot or icy cold waters. And what about correctional law, such as whipping, handcuffing a person to objects for long periods of time and in harsh conditions? And I added this last one, extremely long prison sentences. Why is that a disproportionate punishment? Because long prison sentences don't work. If they did, there would no longer be crime. Life, liberty, property. Due process clause. The 14th Amendment's due process clause prohibits states from depriving any person of life, liberty, or property without due process of law. The two parts of this statement are substantive due process and procedural due process. Procedural due process. The right to procedural due process states that the prison must provide you with some type of protection before endangering your life, liberty, or property, such as a hearing or notification. Procedural violations. It may be a violation of procedural due process if the facility places you in segregation, transfers you to another prison, or takes away your good time credit. Procedural defense. A procedural due process defense has two components. You must first show that you had a liberty interest, and then you must show that you were entitled to greater procedure than you were given. Liberty interest. When the penitentiary infringes on your constitutionally protected rights or holds you in conditions that are significantly worse than the norm for the incarcerated community, you have a liberty interest. If you don't have a liberty interest, a prison doesn't have to provide any procedure. The essentials. Only if a transfer or punishment in prison is excessively and unusually harsh, or if it is done to punish you for something you have the right to do, can you contest it. The rule. The institution must provide you with some level of process if you are subjected to unusual treatment or conditions, as well as substantial hardships of prison life. When challenging your rights in court, these two cases are a great place to start, especially Sandin versus Connor. Warning: if victory would result in the disciplinary proceedings judgment being overturned by the court, you cannot challenge procedural due process in a disciplinary proceeding. The only way to overturn a disciplinary decision is to go through the appeals procedure. The circumstances of imprisonment and the methods by which modern-day slaves are either placed in or freed from administrative isolation are two constitutional concerns that frequently arise in administrative isolation. In Wilkinson versus Austin, the Supreme Court considered procedural due process in a case involving Ohio's most secure prison, a SuperMax facility. SuperMax prisons are maximum security facilities with extremely rigorous rules designed to separate the most dangerous, mentally wounded people from the general population. Almost all aspects of the unhealed person's life are monitored and regulated. Extreme seclusion is linked with incarceration in a SuperMax. Visitation is restricted to a few people and is done through glass barriers. Almost all environmental and sensory stimuli, as well as human contact, are denied to these humans. The Due Process Clause protects people from being deprived of their life, liberty, or property. And anyone seeking to invoke it must show that one of these rights is in jeopardy. In the context of prisons, procedural due process pertains to liberty interest, and the first question in Wilkinson versus Austin was whether a prisoner's assignment to an Ohio SuperMax prison constituted a liberty interest. The Constitution does not create a liberty interest in allowing a prisoner to avoid transfer to more adverse conditions of confinement. And state policies and regulations may create a liberty interest in avoiding particular conditions of confinement, subject to the important limitations set forth in Sandin. Ohio did it. They created a liberty interest. As a result, a SuperMax assignment is protected by procedural due process. Here are 6 more cases to educate yourself on the constitutionality of solitary confinement. Garrison Johnson, a California prisoner, claimed in federal district court that the California Department of Corrections exploited race to assign incoming offenders temporary cellmates. Johnson claimed that this was in violation of the Equal Protection Clause of the United States Constitution. Johnson was found guilty by a federal district court and a federal appeals court. The appellate court cited the United States Supreme Court's Turner v. Safely case from 1987, which stated that when determining whether prison restrictions are constitutional, a loose standard should be applied rather than a strict scrutiny standard. The policies at the prison were fairly related to the administrator's worry for racial violence and thus had to be upheld, according to the appellate court. To sum it all up, a person's constitutional right not to receive cruel and unusual punishment will be honored by federal courts if that right is violated during incarceration. When imprisoned people lack personal hygiene and are deprived of adequate nutrition, the Eighth Amendment is violated. Whether someone is placed in administrative or disciplinary segregation depends on whether or not they have a protected liberty interest. As the state-created system for isolated confinement varies in nature, it is unclear if such a protected liberty interest exists. Prior to Sandin, cases that found protected liberty interest had dubious legitimacy. I have some exciting news for California in 2022, and I want to thank Initiate Justice as they are the co-sponsor of AB 2632, known as the California Mandela Act on Solitary Confinement, authored by Assemblymember Holden. AB 2632 seeks to challenge the use of solitary confinement in jails, prisons, and immigrant detention centers by doing the following. Define solitary confinement as any form of solitary beyond 17 hours in a cell. Ban solitary confinement for vulnerable populations, including disabled people, pregnant women, youth, and elderly. Limit the time spent in confinement to not more than 15 consecutive days, or 20 days total in any 60-day period. Require facilities to keep clear records on the use of solitary confinement in order to provide public transparency. Thank you, Initiate Justice. Thank you, Assemblymember. And thank you to all who will vote yes on this bill. I encourage everybody in every state to advocate for their loved one via legislation. Coming up, Thrive Inside will offer courses on how to lobby in Congress. Stay tuned. If you like these videos and want to see more, I request you head over to Thrive Inside's YouTube channel. A great way to help support Thrive Inside nonprofit is hit the subscribe button and hit the bell. That way you get notified every time Thrive Inside posts a new video. Thank you so much for your support. Now, I want to lift up my conscious, empathetic friend, Dallas Adrian Burgess. Dallas Adrian spent 10 years of his life as a caged human in our prison system. I am happy to report he is out, home, and safe. Upon release a few years ago, he made some choices that allowed him to see things from an angle he felt could bring the most human connection to those around him, and he demonstrates this in his badass rap music. I request we support him by heading over to SoundCloud, following his channel, B.O.M.B Bandana, liking and sharing his creations with the world. Dallas Adrian generously created a song for this specific video. Without further ado, I love to introduce Thrive Inside by B.O.M.B Bandana.
Locked in boxed in, still gotta thrive inside. Minds peep hung off the wall, solitary confined, beating the door in the midnight. Like a kennel full of dogs with New York time. He sound like it's painful to jack the bars. Wild like bars through the slit in the window at night. You can see the stars, no empty is popping off. It took away the yard, talked to no fam in a while. It took away the calls, I do push up till I pass out. Before I be in the turtle suit with my ass out. Man, you ain't crazy, you really trapped inside a madhouse. Property, yeah, the state government take you a cash cow. Livestock, being stock power, holding stock vow. And up in now, sat alone, kicking freestyles. Writing letters, hoping that somebody would reach out. Ain't looking down, I gradually let the beast out. But it was proof the government kept the streets foul. Became feral inside the cell without running wild. The Stanford prison experiment was a test trial to keep the conditions of prison from bringing your best out. Locked in, boxed in, still gotta thrive inside. Minds peep hung off the wall, solitary confined, beating the door in the midnight. Like a kennel full of dogs with New York time. These sunlight locked in boxed in, still gotta thrive inside. Minds be pawns off the wall, solitary confined. Beating the door in the midnight, like a kennel full of dogs with no your time. These sunlight.
It's normal when it's institutional. Circumstances that beforehand would be called cruel and unusual. Standing on top of the urinal, talking through the vent as if I'm in the phone booth. Missing my hood, feeling like I got the home flu. Battling insomnia, Marcelli is in his zone too. Eating mystery meat, neutral, this is dog food, a hard pill to swallow, but sometimes you gotta chew it. On mass con in the gang unit, and I don't bang, but they locked me in the hole with the 9s and the 8 trays. They would jam their doors with plastic forks and slide out on you when you coming back from court. They got the door painted red like it was for blood sport. They squirting diarrhea out, empty bottles of mouthwash. Harsh but this thug life is American, and thriving from the inside of the marathon.
Locked in, boxed in, still gotta thrive inside. Minds be pawns off the wall, solitary confined. Beating the door in the midnight, like a kennel full of dogs with New York time. These sunlight locked in, boxed in, still gotta thrive inside. Minds be pawns off the wall, solitary confined. Beating the door in the midnight, like a kennel full of dogs with New York time. These sunlight.
President class, troublesome past, grocery store for like the child hall, post-traumatic, back on the wall, like ain't nobody watching for me. Stay in the yard like I'm still under lock and the key. Hennessy won't set my mind free, but when I mix it with that weed, it work better than the Dorsey. Feel like a Stanford experiment. The pen is only hostile because it's engineered. It's human geared, it's a Stanford experiment. With no intent of evolving, no developing. Human beings, it's a Stanford experiment. Total trip on the power, on the force that was never meant to uplift. It's a Stanford experiment. Repeat it back because the research was already there. Before the air or the fear that they recommend. With a reprimand, I recollected it was weaponry. A stratagem.
Locked in, boxed in, still gotta thrive inside. Minds be pawns off the wall, solitary confined. Beating the door in the midnight, like a kennel full of dogs with New York time. These sunlight locked in, boxed in, still gotta thrive inside. Minds be pawns off the wall, solitary confined. Beating the door in the midnight, like a kennel full of dogs